Howdy y'all, welcome to Nerd Studio. Hey, we're up in the studio today. Something a little bit different. Now, we don't normally do political videos around here, but this subject was important enough I thought maybe it would be worth giving it a try. So we're going to talk about a case that is being considered by the Supreme Court, that it's an appeal over an assault weapons ban. The name of the case is Friedman versus the city of Highland Park. That's in Illinois. Now, fair warning, I'm not a lawyer. I'm not going to get into, trying to give you legal advice or anything like that, or try and give legal opinion here. What I am is a concerned citizen, and I think if you're watching this video, that probably describes you as well. And I'm going to try and approach the subject from that perspective. So stick with me. This might take a while, and we're going to cover a lot of ground. It's going to be a lot about our gun rights, but really, in the end, I hope you'll see this is really about all of our rights in general. I really have two goals for doing this video. The first, obviously, is to raise awareness about this case, because I honestly do think if the Supreme Court decides to hear it, that it could have big impact on our Second Amendment right, and I think it's important for that reason. But there's a secondary reason I'm hoping I can get a second point across. As I look out and I see all of the stuff on Facebook and all the news media and all the clickbait articles and stuff out there, there's just this increasing tendency for us to get our information through sound bites. I don't know how many people I know who primarily communicate via those funny little pictures on Facebook with, some thought-provoking slogan on it, or some quote that is just completely wasn't said by the guy that's pictured there, or whatever. And I think it is really worth the effort. In fact, I think as citizens, it's important that we do take the time and try and truly understand the facts that surround some of these issues so that we can form truly good opinions. So I'm hoping I can encourage you perhaps to take a closer look at some of this stuff. To help you understand where I'm coming from, let me give you a little bit of background. Like some of you, I would go read these Facebook feeds and the news or whatever, and I would see these sensational articles, and I'd get ticked off, but it started to strike me, some of these stories really seem very sensational. And I thought, man, maybe I'll go back and actually see what was said so I can see it in context. And I found an alarming amount of the time what was being said was, what was quoted was misquoted or taken out of context or attributed completely to the wrong person. Heck, sometimes some of those clickbait articles, the quote that you see has nothing to do with the article underneath them. It was terrible. And so I started doing more research into that and trying to find, is there a way to watch those original sources as opposed to paying attention to the news media and stuff? And what I noticed along that way was that I was starting to butt up against a true lack of information about fundamental stuff in our history and about politics and political systems and about our court systems, things like that. So I started asking around, and I had some friends recommend to me something called the Great Courses. This is done by the teaching company. I'll put a link in the video. What they are hundreds of college-level lecture series on various subjects, all kinds of stuff. And now, this was my process. I'm not saying everybody needs to go out and do it this way. This just happens to be mine, and I want to give you some background. I spent about, over the last 6 months or so, I've spent about 150 hours. I've got a long commute, so I can listen to these things in the car. Going all the way back to the foundations of Western civilization, and up through all the great wars, the Civil War and World War II, and listening to these lectures. Finally, and last night I just finished one on civil liberties and the Bill of Rights, and I thought it was a really good time then to go ahead and talk about this particular case. So that's my background. I did go out and research it, and I thought it really helped. So if you're a big researcher, you might want to check out the teaching company and the Great Courses. So with that, I want to talk a little bit about what I learned, particularly out of this Bill of Rights course, but really over the whole amount of kind of history that's been covered. Judges, when they sit down and they consider the Constitution and they're going to rule in some constitutional issue, they are supposed to make decisions based on some source. In fact, it's so important that the Supreme Court coined a phrase that indicates that they think another judge has just made some BS up. And that phrase is Lochnerizing, and it comes from a case that, I don't know, it was back in the 1900s, early 1900s, Lochner versus so-and-so. but it was just kind of the quintessential case of a judge forming and issuing an opinion where he just made some stuff up. He didn't have any foundation for it. So you'll often hear that phrase referred to, that, oh, that judge was Lochnerizing, and it just means that guy's just BSing. He's just making that up. So let's talk about real quick what some of these sources that they're supposed to use. And this is just a small list. There are more. Obviously, the document itself. Go look in the Constitution. Does the Constitution say yes or no? If it's not there, what they will do is they'll go back and look at old cases. That's called looking at precedent. So they'll go look at an old case that's similar or has some similar issue to it, and they'll see how that judge found, and they will use that and say, oh, well, the precedent says I'm supposed to find this way, and they'll cite that precedent and say, okay, you can't do this because they didn't do it back then. So that's precedent. They also use what's called framers' intent, and what that is, that means the framers of the Constitution, so Madison, Jefferson, I think Hamilton, all those guys that sat down and helped write this document, they try and go back and understand what their frame of mind was when they wrote the document. Kind of an example of that would be, they would use like the Federalist Papers. You can go look that up. I'm not going to go into what that was. But they'll use letters written by Thomas Jefferson. An example of that is kind of an aside, but Jefferson wrote letters to, the Danbury Baptist Church, where he talked about the separation between church and state. And so when the separation between church and state comes up, oftentimes they're actually referring all the way back to some letters that Thomas Jefferson wrote to a church. And that's kind of interesting. But the bottom line here is judges are supposed to cite sources for how they make their decisions. That's not always done. And sometimes, when it is done, sometimes it's done poorly. So they're human. They screw up and they get influenced by political pressure or personal belief, just like anyone else. Another thing you often hear in kind of the soundbite circles is the Constitution is not a living document. Basically, they wrote it, that's what they meant, and it means that, and all of this need for judges and stuff is BS. Well, let me tell you what I think of that. The Constitution is absolutely a living document. How do I know that? So go back and read it. The Constitution is intentionally ambiguous. Well, what does that mean? Go back and look at the language that was used. Freedom of speech. Well, we all know that we have it, but what is speech? How does the Constitution, the document itself, define speech? It doesn't. The framers, the guys that wrote it, went, well, we know what speech is today. We've got handbills and we got newspapers and we got guys on street corners, and that's about it. But we have no idea, how things might change and speech might grow or mutate over time with culture. So they very much intentionally didn't give a definition of speech. And that allows us over time, as our culture advances and changes and speech changes forms, the document can continue to apply to all forms of speech through all time. It was brilliant the way they did it, but it was very much intentional. And when you think about it, particularly if you're watching my channel and you're interested in the Second Amendment, if the document was not a living document, then the Second Amendment right would really only give us the right to bear muskets. Basically arms at the time. And in fact, it says arms. Well, what are arms? I got arms. I mean, they did not define what those things were so that it could advance through time. And these guys certainly understood. They were products of the Enlightenment. They saw their culture growing in leaps and bounds, and they very much were in that brain space. They really did know the culture was going to change because they were seeing it happen in great leaps and bounds in their own lifetime. So the fact that the Constitution is ambiguous tells us that it was intended to be interpreted over time. The other thing that we have as evidence that the document is living and intended to grow over time and adapt to culture is that it's amendable. We have the ability to amend the Constitution. Why do we have that? So we can make up for its shortcomings as culture changes. And we have, of course, amended the Constitution many times. Values and conditions in society change. And our Constitution is very, very unique in the fact that we can amend it. At the time this was done, this was a big deal. We think about it, we sort of take that for granted today. But in reality, when the framers created this document, they went, wow, this is a grand experiment. Nobody allowed their Constitution to be amended in the way that the U.S. Constitution is. Something we don't talk about today. All right, enough of that. Let's talk about this case. So, Highland Park, Illinois, I think that's a suburb of Chicago. I guess I should have looked that up. They passed a law banning assault weapons. And how did they define an assault weapon? Well, they're using a crappy definition. Semi-automatic rifles, which is an invented definition for this. But, things with barrel shrouds and flash hiders and detachable magazines and pistol grips and telescoping stocks and you get the idea. AR-15s is what they're at. They were after the AR-15 and the AK-47. So they passed the assault weapons ban and magazine capacity ban, limiting magazine capacity to 10 rounds. Well, Ari Friedman, who is a pediatrician, lives there in Highland Park, went, well, I don't want to give up my guns. He was being required to destroy them, turn them over to the sheriff, or get them out of the city. And he went, well, yes, and he sued. That suit went to the district court, North District Court of Illinois, I think it was, and they found for the city and said, no, the city has the right to ban these things. And it got appealed, and it went to the 7th Circuit Court. And that's where I'm picking it up, is the appeal of the 7th Circuit Court. So I looked at this, and I went, well, how do I really go about this? And what I did is I went up, and I found the actual opinion that was issued. So when judges, particularly in an appeals court like this, when they have their finding, when they decide, they release an opinion. Now, the 7th Circuit Court has 3 members, there's 3 judges, and what they will do is they will issue a majority opinion, providing they have a majority. In this case, they found 2-1 for the city, for Highland Park. And one judge, and his name is Judge Eastbrook, he wrote what is called the majority opinion on this case. And I went out and found that opinion, and I read it. There's some legalese in it, and it's a little bit difficult, but my experience so far is in every one of these cases that I've read, there are big chunks that are understandable by anyone, usually. And as was in this case, well, you could understand it, but we'll take a look and just see how understandable it is. So they had the 2-1 majority opinion, and they sided with the city. The opinion is full of sort of misleading, misinformation, bad facts, no facts, and he so seldom uses any foundation for any of his findings, I was baffled. And we talked about earlier, judges are supposed to have some source for why they're deciding what they're deciding. So what I wanted to do is I wanted to start by taking a look at some of the quotes from this document, and I'm going to give you a link directly to the document so that you can see where I got these from. And I thought they would really be instructive. Now, I'm not saying we can make legal decisions. I'm not a lawyer, unless you're a lawyer watching this. But I think looking at what this man said should be instructive to all citizens. So let's take a look at some of them. We also know that assault weapons generally are chambered for small rounds, compared with a large caliber handgun or rifle, which emerge from the barrel with less momentum and are lethal only at relatively short range. I'm not sure what he's trying to say there, but this thing reads as if he's saying that assault rifles are only lethal at relatively short range. Now, that might not have been his intent, but I think you can see up here on the screen when I displayed this, he said, we also know that assault weapons generally are chambered for small rounds, parenthetically, compared to large caliber handguns or rifles. So I assume the next phrase, he's still talking about assault weapons, which emerge from the barrel with less momentum and are lethal at relatively short range. I don't think he knows what he's talking about. We all know your AR-15, AK-47, I mean, the AR-15 blow-by-body armor, where most handgun rounds won't. So I don't know what he's talking about there. Makes me wonder if he really understands it. All right, let's take a look at another. And this one just follows right on to that first one. This suggests that they are less dangerous per bullet, but they can fire more bullets, and they are designed to spray fire rather than be aimed carefully. So what he's saying here is you're going to take your AR-15 and spray fire it like this, I guess. He's obviously gotten his He spends a bunch of time in this document talking about machine guns, and he's gotten a misunderstanding of what a semi-automatic rifle will do, and he's confused it with what Hollywood says you do with a machine gun, which is spray fire it. I don't know if you've ever fired a machine gun. I have, and you still got to aim the thing. If you just spray fire, you're not really doing anything but maybe providing covering fire. Your chances of hitting stuff are really bad. So most people who have operated a machine gun with the intent to do harm know that you still hold that thing up and you're still aiming at targets. That's the way it works. And again, I don't think this man knows what he's talking about. All right, next one. If criminals can find substitutes for banned assault weapons, then so can law-abiding homeowners. I think I read this a bunch, and I read the context around this, and I thought I knew what he was trying to say. It's still wrong, and wrong in so many ways. I think he's trying to say criminals aren't using them, so homeowners don't need them for home defense. Well, if criminals don't use them, why are we banning them? It makes no darn sense. And let's be honest, they're criminals. So they go out and get whatever gun they want. Heck, you ban all the guns, they'll start making them in their garage. There'll be all kinds of black market guns out there. You could cheaply make fully automatic submachine guns. You can make them in your garage with limited equipment and really little or no technical skill. If you can weld a bead and run a grinder, you can make a machine gun. I mean, it's not a big deal. So, again, what does this even mean? Next one. True enough, assault weapons can be beneficial for self-defense because they are lighter than many rifles and less dangerous per shot than large caliber pistols or revolvers. I got to say this one again. True enough, assault weapons can be beneficial for self-defense because they are lighter than many rifles and less dangerous per shot than large caliber pistols or revolvers. Huh? Okay, if you're watching this and you don't know, the round coming out of an AR-15, which is a .223 of an inch, 223 caliber, is running at up to 3,000 feet per second. You can shoot just basic off-the-shelf ammo, and it will puncture armor. They are very lethal rounds. In fact, go find one of my videos where I'm shooting cans of cheese with that stuff and see what it does to a number 10 can of cheese. They're incredibly lethal. They are vastly more lethal than handgun rounds. Anybody's going to tell you that. This guy just doesn't understand. He doesn't know. The statement he's making is just complete and utter idiocy. Let's try another. Householders too frightened or infirm to aim carefully may be able to wield them more effectively than the pistols James Bond preferred. James Bond. This is a justice from the 7th District Court making a decision about our fundamental rights, and he's quoting James Bond's preferences. Where is this guy coming from? Okay, I got one more. A ban on assault weapons and large capacity magazines might not prevent shootings in Highland Park, where they are already rare, but it may reduce the carnage if mass shootings occur. May. He would see us limit our fundamental right of self-defense based on the proposition that they may reduce carnage. Real quick, I want to talk about what a fundamental right is. A fundamental right is typically rights you find in the Bill of Rights, which is, the Second Amendment is speech, religion, all of those things. Fundamental means inalienable, and it's stated that way in the Constitution. Fundamental means you were born with that right. You have that right regardless of any human organization, any government. If you prefer, they're granted by your creator. If you don't prefer, it means that you have them naturally. They are a natural right. You have a natural right to self-defense. And this man would limit our natural right to self-defense because it may reduce carnage. That is not justification to limit my fundamental right, let me tell you that. Where is he getting this? Well, he did actually use a source for this. So let's talk about that source. That source is a report entitled An Updated Assessment of the Federal Assault Weapons Ban, Impacts on Gun Markets and Gun Violence. Now, I've read this study. This study was done to study the assault weapons ban that was enacted nationwide from 1994 to 2004. The study is actually kind of interesting to read if you've got the time. But let me give you just one quote about what they found from this study, because this study is used a lot for people that would advocate gun control. So let's hear actually a quote from that study. Quote, "The evidence is too limited for any firm projections, but it does suggest that long-term restrictions on these guns and magazines could potentially produce at least a small reduction in shootings." Is there anything in that statement that would tell you, oh, well, yeah, that's sufficient, we should go make public policy, or wow, we should ban some stuff, that really does justify it? It says the evidence is too limited, but it does suggest that long-term restrictions on these guns and magazines could potentially produce at least a small reduction. They didn't know. There's no proof that that a ban would do anything. It's the only document that they've got, and they are just wringing that thing to death. All right, let's bottom line this. He does cite some sources in his opinion. But he's up against another Supreme Court case. We talked earlier about that, about precedents. And I think this was from, I want to say 2011, 2012, Heller versus Washington, D.C. Now, Washington, D.C., they came out and said, you can't own handguns at all. We don't want them in the city. You can't have them. And Heller sued, and we went all the way to the Supreme Court. The Supreme Court heard it and said, if a gun is in common use, you have the right to use that for self-defense. The government cannot tell you you cannot own it. They also found that they cannot tell you that it must stay in your home disassembled. That was something else that Washington, D.C. tried to say was, well, if you do own it, it's got to be disassembled. And the Supreme Court said, well, that makes no sense because then it is effectively useless and you have removed the right to self-defense. You can't do that either. But they said guns in common use. Now, this judge, I believe, is saying that, no, they said handguns that are in common use. But no one reads Heller versus D.C. that way. So essentially the current law is that if a gun is in common use, you can own it and use it for self-defense in your home. Now, Heller does say that the state has the right to limit where you can carry that gun. And in fact, we have lots of gun-free zones, and that's up for argument. But your right to own the thing is not in question in Heller in anybody's estimation who doesn't have an agenda. They also talk about another case, McDonald. I don't know that much about that. All I'm suggesting is that what this judge in the Seventh Circuit Court did was kind of mangle things, but that's what he's using as a basis. He's saying assault weapons, as they define them, are not covered in that case. So what happens next, or what's going on now? So there is a law firm, Mitchell and Associates, and the National Rifle Association hired them to write a letter to the Supreme Court and said, hey, we're not plaintiffs in this case, but we're friends of the court. And really what that means is we, like all citizens, think there's a good reason for the Supreme Court to hear this case. We think it's been buggered up, and we think you should go make a decision on it. And here's the reasons why. Now, I've read this document. It's pretty amazing. Not only does it have all the technical details right, and it cites all the reasons why really well. It gives all the sources, but there are some amazing quotes coming out of that document. I'm going to read you one here in a second. But so let's say the document's there. What are the possible outcomes? Well, the Supreme Court could decide not to hear this case at all. They don't have to hear any case. They could go, nope, not interested. They don't have to give a reason. Just go, nope. And wasn't always the case. They used to have to. There were some cases they would have to hear, but that's not the case anymore. Lots of case in that word, in that statement. Anyway, if they do hear it, they could find that in favor of the city, in which case they would uphold the assault weapons ban. That could be very bad and have an impact on the Second Amendment in huge ways. I mean, it would allow the government to come into our homes essentially and tell us exactly what we could choose to defend ourselves with. It's very scary, and it would pave the way for a national level assault weapons ban. I have no doubt that that would pave the way. They could have a majority opinion, and most of the judges would say, nope, we find for the plaintiff, and that would effectively, if written correctly, strike down all magazine capacity and assault weapons bans. They could have a decision that separated those. I mean, they can pretty much say whatever they want to say. There's another option, and that's called a plurality decision. And really what that means is that there's no clear decision by the court, no majority. Let me give you an example, and it's just an example. Let's say 3 judges said, well, we think the assault weapons ban is bad and the magazine capacity is bad. And they agree and they write an opinion. And then 3 judges say, well, we think the assault weapons ban is bad, but the magazine capacity that's okay. And so they get together and they write an opinion. And finally, a 3rd set of judges says, no, we think the whole smash is bad, and you can't have assault weapons, you can't have magazines beyond 10 rounds. And so they get together and write an opinion. And essentially what that means is there is no case law established. So there's no change in the law per se from that kind of decision, but the opinions can influence other decisions down the road. So it's not a clear loss or win. Keep in mind that even if this goes badly and they uphold both these things, the dissents that are written in court cases can be very powerful. And that's when the judges, they'll say, well, I don't agree with that, and here's why. Those can be very powerful, and they can affect future decisions that the court might make. Also keep in mind, the court is not the only constitutional actor. And what do I mean by that? I think the common understanding is, no, the court decides what's constitutional. Well, you know what? That actually isn't in the Constitution, that it's the court that does that. And in fact, that actually comes out of a case in 1803 called Marbury versus Madison. And I could talk a little bit about that, but if you're really interested, go out and look it up. But essentially, the Supreme Court sort of seized this power to make these decisions. In reality, the president can decide something is unconstitutional. The Congress can decide something is unconstitutional, and so we, by virtue of our vote, can decide what things are unconstitutional. That's pretty big power. We just all sort of are sitting asleep and thinking, well, that's what the judges do, and that's what the Constitution says. That ain't the case. And I thought that was pretty interesting when I read about it. So think about that. Okay, I promised you a quote from this document, and there were a bunch I could have read, but I think this one is pretty terrific because it speaks to a whole bunch of stuff in one nice paragraph. The purpose of the Bill of Rights is to protect against the destruction of those rights, particularly in the face of emotional arguments when it might be easier to ignore them. During times when the flames of public fears are stoked, upholding the Constitution in face of these fears is a solemn task. I've read this quote a bunch, and there's so much information in here, but really when you look at the mass shootings, and we could talk about how the data shows that these mass shootings are purely media sensation. I like to say the fact that we know so much about these things is because people want to sell toothpaste. Yes, they're horrifying events. They are terrible things, and my heart goes out and aches for every victim of these things. But the media would have you believe there is a mass shooter on every corner, and it's just not the case. And what we are responding to in this country in a large degree, and the reason that these bans are being put into place, is purely out of unfounded fear. I hear people say, oh, I'm afraid to send my kid to school. School will be the safest place I ever send my kid. With the exception of potentially some of the inner cities, where I live, where I've always lived, school is going to be the safest place I ever sent my son. it is fear-mongering that all of these politicians are doing, and all of the judges that have these release these opinions. They're purely playing on our fears. And this quote goes right to the heart of that. Defending the Constitution in the face of those fears is a solemn task. I think it's an amazing quote. And I want to talk a little bit about the NRA. Now, I'm an NRA member. I'm a life member. But honestly, I am a member begrudgingly. I looked at it and I said, well, I think the Second Amendment is very important to me. And I think they're the only ones that effectively go fight for it. I don't like some of their tactics. I don't like the fact that they spam me an email and send me stuff filling up my mailbox and are constantly asking me for money. I don't really appreciate all of that, but it's what we got, and so I give them my membership dues. But it pretty much, for me, stopped there until I read this document. I didn't really understand what the NRA did with that money. I assumed, maybe like many of you, that they paid some really slick guys in suits to go talk to politicians a lot. And I knew they got involved in the court system some, but I didn't know to what degree. Reading this document, it shows not only the technical expertise of the NRA in their ability, at least in their ability to pick good lawyers to go fight these arguments, but their passion that is implied in some of these quotes for those amendments, for that amendment. But it's more than that. When these courts, when they discuss these issues and they cite precedent, they don't silo those things. They don't always only cite Second Amendment cases when they're talking about the Second Amendment, or freedom of speech cases when they talk about the freedom of speech. These findings, these cases, when they are decided, can be used as precedent for all kinds of constitutional issues. And so when they talk about the Bill of Rights here, they're talking about the entire bill, not just the Second Amendment. This idea that we have to stand in face of the fear-mongering and defend this Constitution has wide-ranging impact on all of the Constitution, not just the Second Amendment. And so after reading this document, I got to say I'm a pretty avid supporter of the NRA. And I'm surprised to hear me saying that. In fact, just last night I was at an NRA banquet, and it was interesting that right about the time I discovered this court case and really started to read about it, that Rick at Rock City Guns said, "Hey, we're going to this. You want to come?" And I went, yeah, I do. So there you go. Believe it or not, making a pitch for the NRA. If you have some time, I'll give you a link to this document. There are some great quotes in here if you're interested. I really encourage you to go take a look. Well, that's the end of my notes. I hope you found this video informational, maybe enjoyable. I wasn't as lighthearted as I am in some of my videos, and I apologize for that. But I think it's a pretty serious subject, and I think it's one that really begs our attention. It really does scream out to us and say, hey, there are more to be had here than sound bites. And I really do encourage you to look deeper into these issues. Form arguments that have sound facts behind them. Enjoy Facebook, enjoy the internet. I certainly do, and I certainly put stuff up there. But when it comes down to important issues like this, get the facts. All right, folks, always remember anyone can shoot, and honestly, anyone can read these documents. You really can. It just takes time and a little bit of effort. We'll see you next time.
Yeehaw!